Brunswick. So, you can always see that the jury's out of the courtroom. We're going to ask the clerk to play back. Can you play back that last question and response? Now, the last question and
I mean, one of the big reasons we are all here today, again, as a police officer, if you go against the system, if you upset the wrong person, you're going to be retaliated. There's going to be some type of repercussions for your actions. Mayor Rell's a prime example. The PBA didn't like Mayor Rell, his actions, his decisions, or whatever it may be. They were looking for evidence against Mayor Rell in the room. He was targeted. Minority officers, Anderson, Bird, Amber, Finney, all these gentlemen who have these lawsuits going on right now, we are scrutinized twice as much as the white majority. And when it comes time for promotion, when it comes time for a transfer, all these things are kept in mind. If you're bringing charges or complaints against a non-minority officer, you're not going to get that transfer. Your promotion could be held up, could not happen.
Judge, I move that all of this issue. What kind of evidence does this man have is that the plaintiff is willing to offer in this case that they're not going to be, that none of these individuals got, they're not going to be, that none of these individuals got.
Just make a lot of noise there, Mr.
I sure did, Judge.
Is that a technical error there at the end?
No.
I can repeat my objection.
Please.
Yeah, go ahead, I'll hear your objection.
Well, Judge, as you heard, he's talking about other people that have made complaints. First of all, we know that they haven't made complaints of racial discrimination. He hasn't indicated what they have. They got a lawsuit for pay to play, and if you don't pay to play, you don't contribute to the mayor, you're not gonna be advanced, or you're gonna be discriminated against, so you're not gonna get the right assignments and things of that nature. That's the complaint in the Anderson-Finney. This case is about racial discrimination. He's saying that if you don't, that these people were discriminated against. He hasn't given one piece of evidence to show how Anderson was discriminated against, and then was subjected to discrimination, brought it to the attention of the authority, and then was retaliated against. That's what he's saying on this witness stand, that anybody who steps out of line is going to be retaliated against. He can't say that just because it's his subjective opinion of stuff. That's what the law that we have cited to throughout this case, and why Judge Bergman had such a problem with all of this. This is a hostile work environment claim. Hostile work environment has been dismissed. All claims prior to the statute have been dismissed. And we're allowed this jury to be completely contaminated as a result of this testimony that's being offered by this witness. And he hasn't been Mr. Burke, and I respect him as a trial lawyer, but he has violated Your Honor's instructions to make sure that the proper questions are being asked, and Mr. Middleton has violated your instructions that you told him without directly, not through Mr. Burke, that he is not to talk about what other people have told him. And what are we going to? And what proofs do we have in this case about any retaliation that was ever performed against any of these other individuals? And now it's out there in front of this jury. It's got to be stricken.
Your Honor.
Well, we haven't gotten that far because you've been making your objections.
No, but the testimony that he just gave.
Right. So, Mr. Burke.
Just like I said to the jury, I asked the question Mr. Cannell objected. He said, you don't have a factual basis. We asked for a factual basis. Steve gave it.
Right.
The fact of the matter.
It can't be, and that's why I excuse the jury. It can't be hearsay. It can't
No,
be
no.
What
here's
somebody else said. It has to be things that he observed or actually heard.
That
He
is
has
if
to know
it's
how these other
offered
guys
for
are
the
retaliated
truth.
against.
Right now, what's important, and what I'm exploring with Steve, and I'm sure it's going to be subject to thorough cross-examination. So I want to get it, I want to talk about it now. Because they're focused, and you heard it in all the arguments, you heard it in the open. He didn't make any complaints. When the mayor is aware of a Lieutenant Mangarella, who's later the police director, is making racially insensitive comments, why would Steve stick his neck out? That's what the jury needs to know, and that's what we're getting across. That's what he said. Not only me, but everybody who complains gets hurt. they ignore it. Not only do they ignore it, they retaliate. So that's important for the jury to understand about Steve's state of mind and his mental outlook. Because it's a valid explanation. Mr. Cannell is going to vigorously cross-examine him about what did you know, what didn't you know, what do you know, why didn't you complain, why didn't you do this? And he's going to say what he said now because nobody does anything about it. Not only does nobody do anything about it, it's tolerated at the highest level, the mayor level, the police director level. But people who complain get punished. And that's a valid reason that the jury has to understand.
There's no evidence about this other than what Mr. Middleton is alleging in this lawsuit, that because he filed this lawsuit about his late delay in promotion, that he was retaliated against by being investigated by this attorney, by this hot pursuit. That's the evidence in this case. We're now allowing this jury to think about every black who's ever been employed by the city of New Brunswick has made complaints. We don't know what they are, because we deny that they even made any such complaints. And as a result of their complaints, that they've been retaliated against and not given any promotions. There's no evidence in this case about anybody else. We have to deal with Middleton, because we can't allow this jury to think that this is just because Middleton is saying here on the witness stand that Anderson, Finney, and Ingram were making complaints of racial discrimination, which they did not, and which never got to the city. This Dean Dakin affidavit was never given to the mayor. What was given to the mayor was Sutton and Buckalow came to the mayor in December of 2010 and basically said, we heard a rumor about Mangarelli using a racial slur. That's it. The mayor says, do you have any other information? They said, we don't know who, we don't know what it was about, we don't know who it was. We're investigating, and it's in the hands of our attorney. That Dean Dakin affidavit was never, there's no witness that says it was given to anybody.
Let's go, can you replay that testimony again?
I think you should elaborate on that. I mean, one of the big reasons we are all here today, again, as a police officer, if you go against the system, if you upset the wrong person, you're going to be retaliated. There's going to be some type of repercussions for your actions. Mangarel's a prime example. The PBA didn't like Mangarel, his actions, his decisions, or whatever it may be. They were looking for evidence against Mangarel. He was targeted. Minority officers, Anderson, Bird, Ingram, Finney, all these gentlemen who have these lawsuits going on right now, we are scrutinized twice as much as the white majority. And when it comes time for promotion, when it comes time for a transfer, all these things are kept in mind. If you're bringing charges or complaints against a non-minority officer, you're not going to get that transfer. Your promotion could be held up, could not happen.
Judge, I move that all this be stricken. What kind of evidence does this man have as the plaintiff is willing to offer in this case that they're not going to be, that none of these individuals got transfers as a result of the fact that they had made a complaint that we don't even know has been made? We know that there has been no complaints by Ingram, Finney, and Anderson with respect to race. So this entire testimony is very prejudicial. Your Honor, and it's unsupported the evidence.
Judge, in hearing it again, not only do I believe that it is absolutely justified that it must be stricken, but I submit that we have bordered now on a mistrial. And I believe that this jury has now been tainted by continuing to hear hearsay testimony from this witness. And I was basically giving Mr. Burke a pass on this thing, but I'm not so sure. Because Mr. Middleton has certainly violated your order. We have talked about Anderson, Finney, and Ingram a number of times. You've instructed him that he can't talk about this. And now he's talking about these people actually being retaliated against and making complaints when there is no evidence about that. And how can we allow that testimony to stand? And frankly, he's continuing to violate this throughout his testimony.
The testimony is important because, not for the truth of the matter, but for Mr. Middleton's mental state as to why he took the actions and the inactions that he did. So that's why we're talking about the mayor knowing about racially insensitive comments. He didn't do anything about it. That's why we're talking about Mangarelli using racially, stating what he said to Deacon and
Allegedly.
And this preparation by the union of an affidavit by the president so that they would bring it to the mayor. And we do know the mayor knew of a so-called rumor, but he didn't do anything about it.
There was nothing to do.
Well, wait a minute. There's nothing to do. How about calling the affirmative action officer and saying, hey, would you run down this rumor to make sure that there's nothing out there, because it's our obligation in the city of New Brunswick to eliminate discrimination.
Okay.
How about that?
Mr. Berg, I think we have gone past what his own personal knowledge is at this point. He's talking about Anderson, Bird, Finney, and others who have been scrutinized and bring charges against non-minority cops. You're going to get retaliation and retaliation in general. If you're arguing that that type of testimony is admissible, I need you to find me some case law that would substantiate that. Otherwise, it would seem to be hearsay. And I think you need to spend some time with your client and kind of refine down what it is that he can or can't testify to.
Your Honor, I understand, and I think I've been trying to comply. I understand the rule of hearsay. There is an exception to the rule of hearsay about state of mind. Now, if it's Middleton's state of mind, that they don't do anything about it and
right,
people get retaliated.
His state of mind then would have to be relevant.
Yes, for his actions or inactions. That's absolutely relevant.
Right.
So the only I think what would have run astray, if I may.
The focus is their actions against him, right?
No, the focus is his action or inaction and the reasons why. Okay? In other words, one of the issues in this complaint, in this case, is Mr. Cannell's fervent insistence that he didn't make a complaint.
In his opening and
In his
throughout his objections.
And in all the objections that the jury made. So we want to explain to the jury why that is. Now he can't say, no, you can't explain that. He just can't. It's not fair. Now, and in my mind, the hearsay objection is being abused. Because Steve didn't say, Anderson told me this.
Not the hearsay objection.
No, but Steve didn't say, quote, this out-of-court statement. Steve has knowledge of these things. The source of the knowledge is the source of the knowledge. He didn't talk about what somebody else told him. He talked about the source of his knowledge. Now, Mr. Cannell can explore that through cross-examination. What is the source of your knowledge? And he's perfectly able to do that. But the fact of the matter is, it's Steve Middleton's mental impression that drove what he did. It's fully available for cross-examination about that. The reasonableness of that, the factual basis for it, and all that. But the fact of why he did or didn't do what he did is absolutely important, not only relevant, it's one of the core issues in the case.
Isn't that part of your argument, Mr. Cannell, that he didn't take certain actions, he didn't report it, he didn't do this, he didn't do that, so his state of mind would be an issue as to why he didn't do that?
Judge, his state of mind with respect to what happens to him and what he did and the fact that he was retaliated against and why he believed that he should not bring it to the attention of the authorities. I'm not talking about that. I'm talking about him now introducing these other individuals who he said I've got knowledge of, who have complained of racial discrimination when that hasn't happened. They don't have any lawsuits about racial discrimination. And he hasn't got any proof that they did not get promotions, that they did not get assignments, that they have been otherwise retaliated against. He's talking about basically every black in the police department has been retaliated against. He can't do that.
Your Honor.
You gotta bring in these other witnesses to basically say that, and we're far afield because we are in so violation of the orders of this court, of the orders that are in this case, that I don't think that there's any option but to declare a mistrial.
I think I have to correct a couple of things, because I've heard it 4 or 5 times, these misrepresentations. One is the ruling of Judge Bergman. He said no hostile environment claim because the last incident occurred more than 2 years before filing. Claim, not facts. Facts are important. He never said the facts aren't relevant. Number 2, the Anderson, Finney, and Ingram so-called complaint is not what we're talking about. We have provided an affidavit to counsel of Anderson, Finney, and Ingram that lay out in excruciating detail the discrimination and the retaliation that they each were subjected to and that they know about. So this idea that, oh, they have a different kind of case about pay to play is absolutely false. They have facts about discrimination, retaliation, and specific facts about what happened to them when they complain. Steve knows about those. He knows all about it. Now, I didn't ask him, what did they tell you about that? Because that would be prohibited by the hearsay rule. He did say, what drove you to not make a complaint over everything? And he's explained that to the jury. There's no reason for a mistrial. It's what the case is all about. I know Mr. Cannell doesn't want to hear the uncomfortable facts. He would love to keep all the facts about what happened before February of 2010 away from this jury. He would love to have...
Okay.
All right.
Why don't, so Ms. O'Connor, since you're the research assistant,
yes.
Why don't you do some homework for me as well?
Of course.
And both you and Mr. Burke can email to me tonight in cases you want me to look at with regard to this issue.
Well, Your Honor, the cases that we rely on are in our eliminate motions already. And this goes to the whole argument which we made this morning as to speculation and beliefs. The problem is that there has been no foundation for any of this testimony. Again, we have not been provided with an exhibit list from counsel for plaintiffs. So we have no idea what they intend to mark or where they got these documents. The testimony that they're offering is inadmissible. It's hearsay. There's no foundation for it. And it's just, it's improper, and I agree that this mistrial should be declared because the jury is tainted at this point.
Judge, and I refer you to the order again of Judge Bergman. It's clear in the second page of his order, the second to last paragraph on the page. Order that the motion for summary judgment filed on behalf of the defendant, City of New Brunswick, is granted on the claims of hostile work environment in violation of the LAD, and therefore all hostile work environment claims in violation of the LAD asserted in the amended complaint are hereby dismissed with prejudice. And it is further ordered in a new paragraph.
There's not a claim of hostile work environment. John, can you give
But this is the testimony that we're hearing, is hostile work environment claim.
Right. So what?
And now, the hostile work environment is not the case.
There is no claim for hostile work environment, but are you saying this is not relevant?
Yes.
Okay.
And in the next paragraph,
I
Judge, it
disagree
says,
with that.
order
This is
that all
highly
claims
relevant.
prior to February 28, 2010, outside the statute of limitations, are hereby barred due to plaintiff's failure to prove any discrete act within the statute of limitations on a continuing violation theory. We have totally now ignored the orders that have been provided in this case. We had an opportunity to have a motion for leave to file an interlocutory appeal. Plaintiff did not file any such motion for interlocutory appeal. We did, and that was denied.
We'll be up here at 8:30 tomorrow. We'll try and pick up sometime before I go down to welcome the jurors the issue. So, Ms. O'Connor, if you can, I didn't mean to
No, that's okay, Your Honor.
relieve Mr. Cannell of having to do the homework, but why don't you both sides give me some whatever cases you want me to take a look at, okay? Thank you very much.
Thank you.
Thank you.
Step down.